Okay, hi everyone. We are going to give it another, give it another minute as folks start to trickle in, but wanted to say welcome to our Tree Warden Statutes reading. So we'll just wait another minute or so before getting started. Okay, let's get started. So welcome everyone, and thank you for joining us on this Tuesday morning. My name is Elise Shadler. I am the program manager for the Vermont Urban and Community Forestry program. We also have from the program two other staff. We have Gwen Kozlowski, who's our volunteer and education coordinator, and Joanne Garton, who is our technical assistance coordinator. So you likely have worked with or communicated with one of us in some capacity if you work for a town or are a volunteer or are a tree warden. But we really are just happy that you're all logged on and as interested in this new legislation as we have been over time. So I am gonna kind of lead the read through of the statutes, and this literally will be a read through of the statutes. I think it's safe to say that we're kind of going against all of our general best practices for presentations in terms of pretty much filling the screen with text for the next 45 minutes or so. But we really felt it was important to provide an opportunity for a collective read through and to present the new language in the bill and also have a discussion and open it up for questions about the language. So this will be very text heavy. If you've already read the bill, then this might be a little boring, but we anticipate that some of you have not, and we also are recording this presentation, so we'll have it available on our website for others to watch as well. So, being said, I'm gonna move on to the next slide. So just wanted to give a little bit of context about the Tree Warden Statutes. We have a variety of folks on this webinar. We had kind of initially intended for it to be mostly for tree wardens, but we know that there are folks from RPCs on the webinar, as well as some other town municipal staff, and it looks like some other state agency staff as well. So just wanted to make sure we start off with some context before we get into the language. So the original Tree Warden Statutes were established in 1904, and they were last amended in 1969. So having that historical context and perspective, all the New England states pretty much adopted a tree warden bill of some degree around the early 1900s. And you have to really understand that the vegetated roadside landscape at that time was very different, but also the municipal governance landscape was very different as well. So a lot has changed since these statutes were last modernized or updated. There were some major issues with the statutes as is. There were no definitions. There were the processes that were mentioned in the statutes did not have any defined provisions. They weren't laid out how you would go about doing a public hearing, for example. There were conflicts between different state statutes. So that's a big issue when we're talking about legal interpretation of what language stands when you have conflicting language across statutes. It has caused a lot of conflict with these statutes over time. There were some governance issues, and basically the situation was that towns and tree wardens have really been left to interpret what the statute's language actually means on their own over time. And when we would give presentations about the statutes, we would kind of say that. We just say, like, there's no definition for a shade and ornamental tree, so you kind of get to decide what that means for your town. And while that's great for providing flexibility as different towns wanted to engage with their tree warden and their tree programs, it's not great for having standard language and a cohesive statute. So that was a big issue. And something else that we really kind of realized as we were working through the last couple of years of trying to modernize these statutes was that many towns didn't actually know that they existed. So a lot of the language that we're going to talk about today, or like go through today, particularly outside of the actual tree warden statutes, the language that's referred to in other state statutes hasn't changed. And so there might be questions that come up that we say, well, this has actually already been in place since the 1900s, but just realizing that a lot of towns didn't, or a lot of the staff that we worked with in towns didn't actually realize that this legislation actually existed. So hopefully now we have something that's clear, something that is agreed upon, and something that will be able to serve our tree wardens and our towns a little bit better. The amendments, so this is, if you read the tree mail that went out about this, we mentioned several times that this was a multi-year process. So the first attempt to modernize the tree warden statutes and amend the language was back in 2017. So there was legislation that was proposed in 2017 and 2018 that didn't make it out of the House. And this year, we skipped 2019, and third time's a charm, 2020, there was a big push to get it through. And so what that looked like was a lot of testimony, a lot of partners and stakeholders coming in and providing context about how these statutes really impact a quilt of stakeholders and municipal operations. And so it did actually go through this year. And we're really happy that we came out with something that really demonstrates a collaborative approach to looking at roadside vegetation and looking at tree care and the role of the tree warden in municipalities. As I just mentioned, there's many perspectives. There were extensive edits, so if you have been following the bill, it looks a lot different than it did when it was first introduced. But again, I think what that says is that there was a lot of discussion about it, there was a lot of testimony, and there was a lot of thoughtful, intentional design of the final language that let us have something that we can say is supported by all these different stakeholders. So the new legislation was signed into law by Governor Scott on October 8th, so a couple weeks ago, and it goes into effect on November 1st. So again, while we also have a lot of questions about some of the language, and we are still really even charting our plan for the kind of support that we're going to be able to provide for municipalities and for tree wardens, we thought it was important to at least have this webinar read through recorded and available for folks to watch before the 1st of November when the law goes into effect. So just a couple of links real quick. If you're interested in looking at that trajectory of the bill, the H673 was the name of the introduced bill. And if you go to that link or just even Google H673 tree wardens, it will take you to the bill page. So if you check out that page, there's all the historical documents every time it was brought up in committee, and all the testimony, or all the witnesses that provided testimony, are also listed on that page. And then just to show you again where our website is and how we intend to provide resources for tree wardens and for municipalities, vtcommunityforestry.org is our programs website, and we have a section for Vermont tree wardens. So there's now a subpage just about the statutes, and we have a lot of stuff on there already, but we will continue to build that out, and particularly around the FAQ. I think there's going to be questions that come up today, questions that we're still trying to suss out the answers to, that we want to make sure that information is up on the page. I do think it's important to note before we dive into the actual language in the bill that our program, our role is to support municipalities and tree wardens and volunteers in the stewardship and management of public trees. So our expertise is on the tree side, and we are not attorneys. So I am not going to be providing legal interpretation of any of the language. If you have specific questions about a legal situation or how the language might be interpreted in a specific situation in your community, or how the language might be interpreted to interact with other state statutes, then we are not the right people to be providing that guidance. This is the link to the Municipal Assistance Center, which is the Vermont League of Cities and Towns hub for assistance to towns. They have several attorneys on staff, and the job of the Municipal Assistance Center is to provide that kind of legal expertise for communities and municipalities. So that's where you should go. Or if your town has an attorney, you can also go to them to ask those specific questions. But that being said, we are going to be working with the Vermont League of Cities and Towns to develop a suite of resources that do kind of provide both that tree expertise and the legal expertise. Many of you are probably familiar with the Law of Trees, which was developed probably in the 80s or 90s by Paul Gillies. That document has been widely circulated and I think used by a lot of communities to provide a baseline understanding of the Law of Trees. And it now is out of date. So that's kind of the thing that when I think about what kind of resources we'll be developing with the Vermont League of Cities and Towns, that's the type of thing that we're hoping to pull together. So that being said, please do ask questions. If we don't know the answer, we will keep track of the questions still, and we will make sure that VLCT knows that that's something that folks are interested in hearing about, particularly if it's something that's going to apply to the greater understanding of the new statutes. So before I kick it off, I just wanted a couple things about reading the law. So the version of the legislation that I'm going to be walking through on my screen is the actual act that was signed by Governor Scott. It has not yet been formatted and incorporated into the actual Vermont state statutes. So Vermont Legal Counsel does this. It has not happened for the 2020 legislation yet. So what you're going to be seeing looks a little messy. Once that is updated in the statutes, we'll make sure to link to the clean versions. But for now, we're stuck with, or we're happy to present the bill as enacted. So when you see underlines under the language, that means it's new language that is added. And when you see not stuck through, but struck through language, that is old language that has been removed. So there's a good amount of both in the new statutes. And then just a note on may versus shall, those are two legal terms that are present throughout the statutes. May means can and shall means must. So just understanding that there's a difference there. There are some things that are optional versus some things that are must happen. Okay, so that is the end of my slides. And I just, before we dive into this, just want to let everybody know that Gwen will be monitoring our chat box and the questions. So if you have specific questions as we go along, feel free to put them in the question box or in the chat box over in your GoToWebinar panel. We'll stop at a couple of spots along the way. We have some natural breaking points where we can stop and address questions about a slew of the sections. And then Joanne is going to be taking notes. So we have three of us that are kind of manning this webinar, and really hope to be able to provide all that support. So I'm actually going to turn off my webcam so we can all just focus on the bill itself. Okay, so maybe we'll even start if there are any like overarching questions. Gwen, is there anything yet that's popped in? Okay.
Nope, not yet.
Okie dokie. So, and I think we'll probably spend, I'm hoping to get through this in about 20 minutes, maybe. And then Gwen has some summary slides at the end, and then Joanne's going to talk about the plan, or our plan to support towns over the next couple of months. So here we go. So the statutes themselves, also just of note, is that they're essentially, the edits have happened in 3 separate sections of state statutes. So this first section is all about municipal officers. So Title 24, Section 871. And the only big change here, so a lot of this hasn't changed, but you'll see down in Section B that the select board shall appoint a tree warden who need not be a resident of the municipality and may appoint from registered voters the following officers who shall serve until their successors are appointed and qualified and shall certify the appointments to the town clerk. So this big change is just that municipalities can now appoint a tree warden who's not a resident of the town. So we know that that is already happening, where a lot of towns or municipalities appoint someone who's on staff but does not live in the municipality. And this also allows towns to potentially share tree wardens, which is something we know that has been expressed as an interest in the past by some municipalities. And then the other change in this section is C, which is all new language. After the select board appoints a tree warden, the select board shall certify the appointment to the Commissioner of Forest, Parks, and Recreation. This certification shall include contact information for the appointed tree warden. So this is a reporting element that was added. In the past version of the statutes, there was no way for us, for FPR, for the state to have a database, an updated database of tree wardens, and it's something that we've tried to do over time, but this puts it in writing that the town needs to let Forest, Parks, and Rec know who their tree warden is. And Gwen is going to talk a little bit more about what we think that's going to look like towards the end. So now moving on to Chapter 67 in Title 24, which is the chapter about parks and trees. So this is the bulk of the tree warden statutes. This is kind of what we refer to when we say the tree warden statutes. Section 2501 is all new. This is kind of the crux of the change. We now have definitions for some key terms. So I'm just going to read through it and then talk about what it means. Definitions. As used in this chapter, 1, public place means municipal property, including a municipal park, a recreation area, or a municipal building. Public place shall not include any municipal forest land or property that is subject to any ownership interest held by the Agency of Transportation. 2, public way means a right-of-way held by a municipality, including a town highway. And 3, shade tree means a shade or ornamental tree located in whole or in part within the limits of a public way or public place, provided that the tree, A, was planted by the municipality, or B, is designated as a shade tree pursuant to the Municipal Shade Tree Preservation Plan pursuant to Section 2502 of this title, which is the next section. So basically, what this does is define the jurisdiction of the tree warden. These terms will be in the language throughout the rest of the statutes. So now we know that public places and public ways are explicitly established places. They aren't just left to the interpretation of a municipality or a tree warden. Public places are explicitly established to exclude municipal forest lands, so that's like a town forest. And shade trees, which are the trees that the tree warden has jurisdiction over, are defined as those that either have been planted by the town or have otherwise been specifically designated by the municipality through a process that is laid out further along the line down here. So moving on to Section 2502, which essentially all this language that you're seeing on the screen was deleted, and what that was saying was that the tree warden has the right to implement a shade tree preservation program. And what was replaced in lieu of that was the process to establish a shade tree preservation plan. So instead of just roughly or loosely saying a tree warden can establish a program for shade trees, now we're laying out a process, and laying out the components of a specific plan that the town can decide to accept or not. So A, the tree warden shall control all shade trees within a municipality, and we have just defined what a shade tree is. B, the tree warden and the legislative body of the municipality may adopt a shade tree preservation plan. So they can adopt the plan. The plan shall, 1, describe any program for the planting of new trees and shrubs, 2, provide for the maintenance of shade trees through feeding, pruning, and protection from noxious insect and disease pests, 3, determine the apportionment of costs for tree warden services provided to other municipal corporations, 4, determine whether tree maintenance or removal on specific municipal property shall require the approval of another officer, municipal officer or legislative body, and 5, determine the process not inconsistent with this chapter for the removal of diseased, dying, or dead shade trees and any shade trees that create a hazard to public safety, impact a disease or insect control program, or must be removed to comply with state or federal law or permitting requirements. In addition to that, C, the shade tree preservation plan may, 1, map locations or zones within the municipality where all trees in whole or in part within a public way or place shall be designated as shade trees. And 2, designate as a shade tree any tree in whole or in part within a public way, provided that the tree warden and legislative body of the municipality find that the tree is critical to the cultural, historical, or aesthetic character of the municipality. So essentially what that's saying is the shade tree preservation plan, if a town decides to adopt one, has to have the first 5 components. Additionally, they can decide to designate additional trees within the municipality to be shade trees and thus be under the jurisdiction of the tree warden. They can either do that through mapping. So it could be, hey, we want every tree within the designated downtown district in our public ways and places to be designated as a shade tree. Or, hey, we have, these 6 roads that we would like the trees to be considered shade trees. Or you could even go as far as designating individual trees that have cultural, historical, or aesthetic character to the municipality. Those are very subjective terms, and again, the intent is to provide as much flexibility to the municipality to decide which trees and how those trees should be managed. D, sorry, this is a long section. D, the tree warden and the legislative body of the municipality shall hold a minimum of 1 public hearing concerning the shade tree preservation plan for the purpose of soliciting public input. The legislative body shall publish the proposed plan 10 days prior to the public hearing. So this just ensures that a shade tree preservation plan does go through a public process. There are opportunities for residents to have input on that plan before it's adopted. And then E, for the purpose of promoting the public health, safety, welfare, and convenience, a municipality shall have the authority to adopt an ordinance that is not inconsistent with this chapter for the administration of the shade tree preservation plan and the regulation of shade trees. The tree ordinance shall be adopted pursuant to Chapter 59 of this title. And Chapter 59 is section in Title 24 around adoption and enforcement of ordinance and rules. So this is kind of the extra layer. So if the municipality adopts the shade tree preservation plan, they can also codify that in their municipal law by turning it into an ordinance or developing an ordinance that specifically enforces what is laid out in that plan. So we have several municipalities in the state that have already adopted tree ordinances in the past, and there was never an explicit mention of that being allowed. And so this was added mostly to say, like, yeah, you can have an ordinance that strengthens your program, and here's how it happens, or here's how it can happen. And then section 2503, this is not a big change. This was already in the statutes. A municipality may appropriate a sum of money to be expended by the tree warden, mayor, alderman, select board, or trustees for the purpose of carrying out this chapter. So there can be a budget, essentially. I think we're gonna stop there and take some questions if there are any. Gwen?
So far, no questions, but let's just take 30 seconds or so if folks want to type out anything that they have on definitions or clarifications so far. Or you can raise your hand. All right, so far nothing's coming through, but I'll let you know.
Okay, great. Okay, moving on. Still in chapter 67, so still in parks and shade trees. Now we get into the language around removal of shade trees. So you'll notice we added shade. So now we're specifically, again, referring to those trees that the tree warden has jurisdiction over, so the shade trees that have either been planted by the town or that have been designated. So the tree warden may remove or cause to be removed from the public ways and places any trees that are infested with or infected by a tree pest or that constitute a public hazard. The noticed and hearing requirements of section 2509 of this chapter, which we'll get to, shall not apply to the removal of infested or infected trees. B, the tree warden may determine that an owner or a leasee of a budding property has sufficiently controlled all insect pests or tree diseases upon the trees within the limits of a public way or place abutting the property, and may determine that it is not necessary to remove the trees. So this section was already in here, but we modernized and just clarified the language a little bit. And by we, I mean the legislature. The idea that if you have a tree, for example, an ash tree in the public right-of-way in front of someone's home, the tree warden, and it had been planted by the town as a shade tree, the tree warden technically would have jurisdiction over that. But if you had a resident who felt very strongly that they wanted to preserve that tree through insecticide treatment, and that was okay with any other processes and regulations in that specific municipality, the tree warden could determine that they wouldn't remove that tree, that they would keep the tree there. So that's just an example of what that might look like. 2505, deputy tree wardens. This also existed, but some language was added. The legislative body of a municipality may appoint deputy tree wardens who shall serve under the direction of the tree warden and shall have the same duties and authority as the tree warden. The legislative body of the municipality may dismiss a deputy tree warden at its pleasure. So this shifted the responsibility from the tree warden to appoint to the legislative body to doing that appointment and that dismissal. 2506. Regulations for protection of shade trees. A tree warden shall enforce all laws relating to shade trees and may propose to the legislative body of the municipality the rules, ordinances, or regulations for the planting, protection, care, or removal of public shade trees as he or she deems expedient. The legislative body of the municipality may adopt the rules, ordinances, or regulations pursuant to the provisions of Chapter 59 of this title. So again, this was already here, just some alterations to the language. 2507 is cooperation. With consent of the legislative body of the municipality, the tree warden may, 1, enter into financial or other agreements with the owners of land adjoining or facing public ways and places for the purpose of encouraging and effecting the shade tree preservation plan. 2, enter into agreements with other municipal corporations to provide tree warden services or training. That's new language that was added. Or 3, cooperate with federal, state, county, or other municipal governments, agencies, or other public or private organizations or individuals, basically anyone, and may accept on behalf of the municipality any funds, equipment, supplies, or services from organizations and individuals or others as deemed appropriate for use in carrying out the purposes of this chapter. And the only thing I'll say about this is that section, or number 2, the other municipal corporations piece was added, I believe, to address some other municipal code that designates the town manager or the select board in charge of certain properties. So I think cemeteries were one of them. So this would allow the tree warden to essentially have an agreement with the town that they would actually be in charge of those trees. Section 2508 is cutting shade trees prohibited. Except as otherwise provided in 19 VSA Chapter 9. Title 19 is all about highways, so we'll get to Chapter 9 at the end. It's the last couple pages of this, but just understanding that when it refers to Title 19, we're talking about highways, town highways. Except as otherwise provided in 19 VSA Chapter 9, a shade tree shall not be cut or removed in whole or in part except by a tree warden or his or her deputy or by a person having the written permission of a tree warden. That was existing language. And 2509 is where there were a lot of changes. So this section is about cutting shade trees, the notice and hearing. So you'll see the crossed out language was pretty short and just essentially said that that there are situations in which no hearing is required. So this elaborates on that a little bit more. The tree warden shall post public notice of the intent to cut or remove a shade tree. The notice shall be posted a minimum of 15 days prior to cutting or removing the tree. If the cutting or removal is appealed pursuant to subsection C of this section, the legislative body of the municipality shall hold a public hearing. This subsection shall not apply to the cutting or removal of shade trees, of a shade tree or trees that, one, are infested or infected by, or at risk to become infested with or infected by a tree pest and are located in an infestation area designated by the Agency of Agriculture, Food and Markets and Department of Forest, Parks and Recreation. 2, are a hazard to public safety, or 3, must be removed by the municipality to comply with state or federal law or permitting regulations. So just to summarize what that says, we're getting into the process that the tree warden would go through to remove a shade tree. If the shade tree fits any of these 3 definitions or situations, they don't have to hold a public hearing. But if the shade tree does not fit any of these definitions, then the removal has to be posted a minimum of 15 days before cutting the tree. Point number 1 here, this is to, I think this was largely put in here, understanding that right now we're dealing with emerald ash borer in the state. And as the statutes had said, the tree warden couldn't take down a shade tree without a public hearing unless the tree was visibly infested or infected with a pest. But as we know, with a pest like emerald ash borer, the tree can be infested for several years before it is actually noticeable by visual assessment. So this was added to say, essentially, if you're in an infested area, you know that ash trees are at risk for by emerald ash borer, you can go ahead and remove those trees without holding a public hearing. Down to section B here, which so if the tree that is intended to be cut or removed does not fit any of those 3, here's the process for holding a public hearing. The tree warden shall post public notice of the intent to cut or remove a shade tree or a group of shade trees pursuant to subsection A of this section in at least 2 conspicuous locations within the municipality. The tree warden shall post the public notice in or near the office of the clerk of the municipality. So guidance to where those notices need to happen. When the shade tree or group of shade trees are located on property held in fee by another, the municipality shall notify each abutting landowner at the landowner's address of record. So in addition to those 2 public notices about the removal, if it's a right-of-way tree, the adjoining or abutting landowners also get specific notice that the tree or trees will be coming down. Within 15 days after the posting of public notice, a resident or landowner may appeal in writing to the legislative body of the municipality to object the cutting or removal of a shade tree. The legislative body of the municipality shall give notice of the appeal to the tree warden. So if that happens, within 10 business days after receipt of an appeal, the legislative body of the municipality shall hold a public hearing with the tree warden to receive public comment on the proposed cutting or removal of the shade tree. The tree warden shall stay action on the proposed removal until the legislative body of the municipality renders a final decision on the appeal. In all cases, the decision of the legislative body of the municipality shall be final. This is a lot to unpack. This went from essentially being a line that said a public hearing shall be held to a very detailed process and much better guidance on how a public hearing would be held. And one of the big changes that is that in the past there was no that last section there. In all cases, the decision of the legislative body of the municipality shall be final. It puts the final decision on the select board or the legislative body and not on the tree warden themselves. So that is a shift. And were we going to stop there for another break?
Yep, and so far there's just one clarifying question about trees occurring within the public right-of-way of municipal roads, and they are not automatically considered shade trees, and that is correct. If the tree was not planted by the municipality, it does not necessarily count as a shade tree, but again, it can be identified in the shade tree preservation plan if the community would like to have that be under the jurisdiction of the tree warden.
Great. Thanks, Gwen, for answering that. Okay, we're in the final stretch here. And then I can stop talking. Okay, 2510, penalty. So there was a change here. So this is an existing section. No big changes in section A, which essentially says if somebody mars or defaces a shade tree without the written permission of a tree warden, or the legislative body, they shall be fined no more than $50. But if in section B, if any person willfully and critically injures or cuts down a shade tree without permission of the tree warden or the legislative body of the municipality, they shall be fined pursuant to Title 13, Section 3602, which Title 13 is crimes and criminal procedures, and Section 3602 is essentially valuation of timber based on DBH, so based on the size of the tree. So it's not a static $500 as was in the past. Now it's in relation specifically to the size of the tree that was removed. And that penalty would be fined and for the use of the municipality, which has not changed. Section 2511 is about control of infestations, and this section was in existence. You'll see that a lot of the language was struck. So we essentially, the language was simplified a little bit. So now it reads, when an insect or disease pest infestation upon or in shade or private trees threatens other public or private trees, is considered detrimental to a municipal shade tree preservation program or threatens the public safety, the tree warden may request surveys and recommendations for control action from the Secretary of Agriculture, Food and Markets, or the Commissioner of Forest, Parks and Recreation in accordance with 6 VSA Chapter 84, which is Title 6 is around agriculture and pest survey detection and management. So essentially, if a tree warden is concerned about an infestation, they can request from either the Secretary of Ag or the Commissioner of Forest, Parks and Recreation surveys or recommendations. That is the end of Chapter 67. So that's the end of the municipal trees and parks section. The last few sections are in Title 19, which again is highways, and Chapter 9 relates to removal of roadside growth under the subchapter of general duties of towns. So this is a whole nother statute. And I will say that the Agency of Transportation was involved in the edits in the final language, as was the Vermont League of Cities and Towns, as I mentioned before. So this is, somewhat outside of our general expertise. It's not specifically about trees. It's about all roadside vegetation, but it was amended to specifically not contradict, as it had in the past, with Chapter 67 in Title 24. So removal of roadside growth, except for work that is part of the transportation program under section 10G of this title, And I will just note that that is referring to the Agency of Transportation's program. So that's what 10G is about in section 901. Sorry, there's so many numbers and sections, and got a real 101 in state statutes through this process. But when it mentions the transportation program, that's not referring to municipal, that's referring to the Agency of Transportation's program. 1, a person shall not remove shade trees as defined in 24 VSA, section 2501A, which we just looked at, without prior approval of the tree warden pursuant to 24 VSA chapter 67. So essentially just a nod that the tree warden statutes exist, that there are trees within towns that are designated as shade trees or are just inherently by their nature shade trees, and that this the town highway should be managed in a way that respects that and recognizes that. 2, a person other than the abutting landowner or municipality shall not cut, trim, remove, or otherwise damage any grasses, shrubs, vines, or trees growing within the limits of a town highway without having first obtained the consent of the legislative body. So this language was already in existence, and what was just changed was adding the municipality in that first line, and then shifting to the legislative body instead of the Board of Selectmen for town highways at the end. And then this was added, section 3. A person other than the agency or the abutting landowner shall not cut, trim, remove, or otherwise damage any grasses, shrubs, vines, or trees growing within the limits of land subject to any ownership interest held by the agency without first obtaining the agency's written consent. So this was specifically added by the Agency of Transportation. 902, penalty for removal. And this was amended to align with the change in the penalty in Chapter 67. So again, referring to Title 13, Section 3602, which is that valuation of timber. So A, a person other than the agency, the abutting landowner, the municipality, or the tree warden who willfully or maliciously cuts, trims, removes, or otherwise damages trees within the limits of a state highway or municipal right-of-way shall be fined pursuant to 13 VSA section 3602 unless the person has obtained prior written consent from the agency, municipality, or tree warden. A person other than the agency, the abutting landowner, the municipality, or the tree warden who willfully or maliciously cuts, trims, removes, or otherwise damages grasses, shrubs, or vines within the highway limits in violation of section 901 shall not be fined more than $100 nor less than $10 for each offense unless the person has obtained prior written consent from the agency or municipality. So what these 2 points, basically this in the past, in the original statutes, was one section that didn't split out trees from grasses, shrubs, and vines, and now it's 2 separate points, one referring to trees and the penalty for removal of trees, and then one referring to the removal of grasses, shrubs, or vines. And nearing the end here, tree and brush removal. This again was existing and there are just some additions made. The legislative body of a municipality, if necessary, shall cause to be cut and burned or removed from the limits of the highways under their care trees and bushes that obstruct the view of the highway ahead or that cause damage to the highway or that are objectionable from a material or scenic standpoint. Trees that have been set out or marked by the abutting landowners and shade trees that have been designated pursuant to 24 VSA Chapter 67 shall be preserved if the usefulness or safety of the highway is not impaired. Young trees standing at a proper distance from the roadbed and from each other, and banks and hedges of bushes that serve as a protection to the highway or add beauty to the roadside shall be preserved. On state highways, the secretary shall have the same authority as the legislative body. So this, I know there have been a lot of questions about this, particularly the language around plants or trees, bushes that are objectionable from a material or scenic standpoint. And the one example that made that make sense to me was something like an invasive species, which might not obstruct the view or cause damage to the highway, but would be objectionable from a material standpoint. as an invasive species. And then just the addition of adding the call out to Chapter 67 again recognizes that the tree warden statutes exist and that the tree warden has jurisdiction over specific trees. That is the end. The last section is the effective date. This act shall take effect on November 1st, 2020. And it was signed again on October 8th. And I'm done with my read through. So Gwen, are there any other questions that popped up through that last section?
Yes, so there was another clarifying question about to declare all trees in a town right-of-ways, shade trees to be protected. All the community needs to do is map the right-of-ways along each road and declare them shade trees, right? Well,
correct. Well,
correct, but there's the limitations that you need to follow the shade tree preservation plan and incorporate all 5 of those requirements, and also have a public hearing to gather input, and then have that plan be approved by the select board. So
yes.
It's not as simple as just planning and mapping them. That has to also get approval and community input. We've got another question. Where does Green Mountain Power trimming fit into these statutes within city limits?
That's a great question. I believe there's a whole section on utilities in state statutes, and I don't have any familiarity with those. So that would be a great question for us to take back to VLCT. That will be something that people will want to have clear guidance on.
Great. The next question in section 902, which is the penalty for removal. There was a question, is this irregardless of shade tree status?
So I'm assuming this is referring to the section A. So essentially saying that all trees within the along the roadsides or along our highways are either under the control of Agency of Transportation, the abutting landowner, the town, or the tree warden, depending on the specific stretch of road and whether or not those specific trees are designated as shade trees. So this is saying that those 4 entities can remove trees, but if somebody other than that removes those trees, then they can be fined. So I think that that would essentially, again, so recognizing that they've already given a nod to the tree warden statutes, if the specific trees in question were shade trees, then they would defer back to the provisions in Chapter 67. Does that make sense? That might be another section that needs a little bit more sussing out and clarity.
I think that makes sense, and let us know if that didn't clear it up for you. But otherwise, we're caught up on questions right now, so we could kind of switch gears to the summary part of the legislation.
Yeah, great. Well,
okay.
Gwen, I'm gonna turn it over to you, and I'm gonna put myself back on screen.
All righty, so there's another question here. What about trees that disturb the sidewalks or create an uneven sidewalk?
So if that would be considered by your municipality to create a hazard to public safety, then I think the tree warden has the authority to remove those without a hearing. I think that would be something that might be interpreted differently by different people, and we don't have clear guidance on that. So we'll note that as a question.
Great. So that was a lot of information. Thank you so much, Elise, for taking us through that. I think it was.
I will also just say, Joanne and Gwen know this, but I have a sick 6-month-old at home and a 3-year-old who has to stay home because the other one is sick per the new pandemic guidelines. So I am hiding in the basement right now. And as I was going through that, I heard lots of noises upstairs. So I'm hopeful that you all did not hear those. But I'm done talking. So Gwen, you go ahead.
No worries. Well, thank you again with all the craziness going on in your household for leading us through that. And as Elise noted, This is a municipal law and falls upon municipalities to address and comply with the new statutes. And our role with this program is really help facilitate sharing this information about the changes. And like we noted before, we can't address those specific legal questions, and there is still some flexibility in some parts of the statute. But again, direct those questions to your town attorney or the Vermont League of Cities and Towns. So we thought it would just be helpful to boil the bill down into like a few simple steps that your community can comply to be in compliance of the new statutes. So this is intended to be just a shorthand little list. As Elise noted, you know, not a ton is going to change on November 1st. There's really no enforcement arm, but we want to encourage participation and help municipalities comply with the updated statutes. So our first 5 steps of quick steps for getting started. And number 1, you're already ahead of the game, is reading, oops, let's see. Yeah, now as a presenter here, let's see. Okay. Reading the statutes, you're ahead of the game. As we noted, there's been over 100 years of municipal law and changes to the ecological landscape. So there really was, you know, a need for the updated statutes here. And as you heard, there's a lot of different compromises between stakeholders, but now that there are clear definitions of the jurisdiction of the tree warden, opportunities to expand that role, clear guidance on hearing procedures, and elimination of conflict between those other municipal statutes, we really hope that this actually helps elevate the position of tree warden in municipalities over time. As the role of the tree warden has changed over time as well, and we hope that now that those responsibilities are more clearly laid out, it helps to elevate that role. And as Elise noted, we don't have the clean bill version yet, but we will share that as soon as it's made possible. Step 2 is appoint a tree warden. So as noted earlier, the tree warden does not need to be a resident of the municipality, and municipalities can share the tree warden. Of course, that needs to be negotiated out between legislative bodies, and the details of that are spelled out in section 2507, cooperation, especially if there's any financial compensation that needs to be identified in the shade tree preservation plan. As Elise noted, there is no term limit or yearly appointment, and the tree wardens can serve until a successor is appointed. It's also important to note that there are no specific qualifications detailed to become a tree warden. Stakeholders were worried that specific qualifications may actually deter engaged citizens from stepping up for this position. As Elise noted, we tried to collect a list last year of tree wardens across the state, and a number of communities just don't have a person appointed, but the select board fills that role, and that continues to be acceptable. It's not spelled out in this particular legislation, but under other municipal statutes, if no one is appointed, the default goes to the legislative body or select board. Next is reporting the tree warden. So with this aspect, as Elise noted, there is a little less guidance on specifics, and it's again up to the municipalities to comply with the state statutes, but our program would like to make it as easy as possible for volunteers and town clerks to provide this information. So we will be putting a button on our website that links to a contact information form. So that's one way that a municipality can comply. There's no specific deadline, there's no term limits, there's no association with town meeting day. So it's a little bit of a free-for-all right now. So you might have to bear with us on the best way that we could help support you. So if you have suggestions or comments, please feel free to put them in the question box or email us. And Joanne will be talking about an upcoming survey that we could collect your information and input as well. Step 4. Review the jurisdiction and definitions. And for many communities, this might be where you stop to comply with the legislation. Because like many other Vermont things, there's no one size fits all, and municipalities have the power to identify the jurisdiction of the tree warden. At minimum, tree wardens are responsible for trees planted in the municipality in public ways or places. And as a reminder, those definitions are on the screen. And those are in section 2502. In some rural communities and small communities, I think there was a note in the question box, there actually may be few or no knowingly planted trees, and therefore the role of the tree warden is actually quite limited. Remember that public places excludes town forests or land with an interest owned by the Agency of Transportation. And there you might be thinking, well, what if we don't know if a tree has been planted? If it's unclear if the municipality planted that tree and you'd like it to be under the jurisdiction of the tree warden, then you must identify it in a shade tree preservation plan. And some of you might be thinking, well, what about those 100-year-old sugar maples that we have along the right of way? If you don't have identification on whether or not those have been planted by the municipality and community members want to have those preserved and managed, that particular stretch of the road, again, they must be identified in a shade tree preservation plan. But again, this might be where some communities stop. But if you'd like to expand that role in the jurisdiction of the tree warden, a municipality must create a shade tree preservation plan as discussed earlier. So these plans must have those 5 outlined elements, and that's a must with the planning and maintenance program, cost of tree warden services, and removal approval needs. You may be thinking, do you have an example? And unfortunately, we do not yet, but Joanne will be discussing how we could work with select communities to create example plans in 2021. And you may be asking yourself, well, our community has an action plan or a tree ordinance or policy or management plan already. Does this count as a shade tree preservation plan? And unfortunately, the answer is maybe. The shade tree preservation plan is explicit in needing those 5 required elements. And I suspect that many communities may actually want to expand that role. So you might need to actually spell out the additional locations or zones in which you want the tree warden to be responsible. And additionally, there's at least 1 public hearing that must be held to gather input. So perhaps your community has some of those elements in your shade tree preservation plan or in your management plan already. You might be able to incorporate the rest of the information needed, hold a public hearing, and be able to get that passed and adopted by the select board as your shade tree preservation plan. This wasn't intended to be another plan on the shelf. The legislation was added to empower communities to actually identify areas that they would like to preserve and manage. And with that, it really brings us up to date with what you need to do to be in compliance with the legislation. Again, you don't have to rush out today and create a shade tree preservation plan, but it's an option for communities who want to plan and care for their public trees in a thoughtful way. And we hope that this empowers you to be able to make a difference in your municipalities and ensure good stewardship for years to come. So with that, Joanne, well, I'll take a look at the questions, and otherwise I'll pass it over to Joanne.
There is one question that came in. If a town does not have or adopt a plan, then all trees in the road right-of-ways can't be removed by the abutting landowner or the municipality with no penalty, and that's correct, if the trees are not shade trees or designated shade trees. Okay, Joanne, wrap us up.
Great, thanks. Yeah, so just to finish up of kind of next steps and what's coming from our program and partnerships with other programs, there's really just a couple of things that we are scheduling as we speak. The first is really this partnership with Vermont Leagues of Cities and Towns. We have, over the next 9 or 10 months, an opportunity to work with them to provide a new manual, essentially, that includes legal guidance. And that comes from Vermont Leagues of Cities and Towns, but certainly we'll have our input and our questions that come from you to inform that document. And we'll also be facilitating and providing some webinars on that information as it comes out. It'll take a couple of months. It won't be ready by November 1st by any means. But that's kind of on our dock over the next couple of months. We are also hoping to work with 10 towns, probably starting in January, to create and draft your shade tree preservation plans with input from you. And that would be partly in assistance to these 10 towns and partly for us to start creating this library of example shade tree preservation plans, acknowledging completely that they'll be quite different from town to town. So we'll be coming up with a clever way to select those towns pretty soon. And again, to start that in the new year so that those examples are ready within a few months of these new statutes going into effect. And Gwen and I will probably follow up with a few survey questions that just start to ask you or other people in your town, such as your town clerk or town administrator, what you envision the easiest ways of some of these amendments being enacted, such as the reporting element, looking for your ideas so that we don't make things any more complicated than they need to be, and also start to nuance things according to what is easiest for each town. And lastly, we'll have a lot of partners who are interested in the tree warden statutes, in addition to tree wardens themselves. I know we have a variety of people on today who play different roles in municipalities. We'll also be working with Vermont Local Roads to give a webinar with them probably in January as well, perhaps December, speaking directly with the road foremans and fielding some of their questions too regarding trees along the roads.
Fantastic. We are at 12:01. I just wanted to make sure we got all the questions.
Yep.
Just a call out from Dave that he's interested.
Awesome.
Thank you all so much for joining us. And again, sorry this was so dry and so text heavy, but now we have it, and hopefully folks who want a facilitated read through of the statutes can use it, and we'll continue to work with those partners to probably do repeats of this. But we are excited and we're thankful for you wanting to join in on this, and hopefully you're excited as well. I think just having, again, something that's supported and that puts the power within each municipality to determine the extent of the tree warden role is a great spot for us to be in. So with that being said, we'll say goodbye, be on the lookout for some survey questions, and hope you have a good rest of your week.
Thanks all.
I'm going to end the webinar, Elise.
How do I do it?
Do it.